As with my colleagues on the podium here, I am absolutely delighted to be here in Bangalore today, particularly because I went to high school here a number of years ago. I'm not going to say how many. After that, in subsequent years, I went on to the US, where I got a PhD in biochemistry and got my law degree from there, worked in a patent law firm for a few years, and moved on to Canada, where I'm currently a partner in the Vancouver office of Borden Ladner Gervais. My practice is primarily focused on patent prosecution and opinion work in the biotechnology and pharmaceutical areas, and with a little bit of additional inorganic chemistry and chemistry work. So very much in the unpredictable arts. Today's talk, though, is going to be very procedural, so not really restricted by field in any way. What I'm going to talk about today is really, in recent years, the Canadian Patent Office has instituted a number of different options for accelerating prosecution that have advantages and disadvantages. So I'm going to start out with just a brief overview of our patent system, talk about the different options that we have for requesting examination and conducting prosecution of a patent application, and discussing the pros and cons of each, and we'll hopefully leave you at the end of the talk with some strategic thoughts on how to elect one or the other of these options. So basically, Canadian patent law, we are common law jurisdiction, so we are governed by the Canadian Patent Act and patent rules, and as you heard from my colleague Elliot here, a fair bit of sometimes difficult to comprehend case law. As with many other jurisdictions, Canadian applications are published 18 months from the earlier of the filing date or the earliest claim date. Claim date is essentially the priority date. Again, as is fairly standard now, the maximum term of a Canadian patent is 20 years. And what is more pertinent to today's talk is that patent applications in Canada are not automatically examined. We have maintenance fees payable on an annual basis, beginning on the second anniversary of the filing date. For practical purposes, what that means is for a Canadian national phase application, it's 2 years from the international filing date. Failure to pay a maintenance fee may result in loss of rights. However, Canada has a fairly generous reinstatement provision where in most cases, if you miss a deadline, you're able to reinstate an abandoned application within 1 year of the missed date upon payment of a fee. So the options for examination that we have is just regular examination. We have advanced examination, which is also called special order. We have patent prosecution highway programs, and we have a green technology initiative. For regular examination, which is for now the vast majority of Canadian patent applications, examination must be requested. There's a fee associated with it by the expiration of 5 years from the Canadian filing date. And interestingly, most submissions before the Canadian Patent Office must be made by the applicant or the applicant's agent. There are a few exceptions. Examination is one of those. So any person, a third party, can request examination of a Canadian patent application, although after that examination, if there's a third party request, the Canadian Patent Office notifies the applicant. The third party requester does not have any other say in the prosecution. The problem with regular examination in Canada, I think, is a problem that's probably is found in many jurisdictions worldwide, there's a significant backlog and significant delays in getting the first office action after requesting examination. These numbers are from the Canadian Patent Office website, and as you can see, they're a few years old now. But there are significant delays, and frankly, in my experience, these are conservative estimates for organic chemistry, general chemistry, and biotechnology, which are the areas in which I practice. We very often wait 3 years for a first office action. So one way of dealing with that is to not wait until the 5-year deadline to request examination, and instead request examination at the time of, say, national entry. However, and this I think happens perhaps more often in the life sciences and biotechnology, there can be a strategic value to delayed prosecution. Companies may want to gauge what scope they're getting in other jurisdictions. They might want to align their Canadian prosecution with patents or prosecution in other jurisdictions. So the delay is not necessarily a negative. For those cases where a delay is not desired, we have the advanced examination or special order option. For any case, the applicant can request advanced examination by simply submitting a statement saying that failure to do so is going to prejudice the applicant's right, and by paying a fee. It's not clear what exactly would constitute a failure to prejudice the applicant's right. I'm not aware of any case law on point. I don't know if Elliot, feel free to step in if you know of one. I don't believe there has been any discussion on this issue at the court level. So our interpretation is that a prejudice, an applicant's rights could be prejudiced, certainly in the case of potential infringement, but for a variety of commercial considerations as well. Advanced examination can only be requested if the application has been published, so laid open to public inspection, and also an examination request has been made. If not, the request for early publication and for examination can be made concurrently with a request for special order. As with regular examination, an advanced examination request can be made by any persons, but only if the application has already been laid open. Some of the advantages of the advanced examination is that it can be requested at any time. I've had a number of cases where we were fairly advanced through prosecution. We were on maybe the second office action, at which point my client decided that due to various reasons they wanted a quick allowance of the case, and we were able to request a special order and expedite prosecution. However, there's been some recent changes instituted by the Canadian Patent Office where, if you recall, I said earlier that Canada has a very generous reinstatement provision. So if you miss a deadline, you can reinstate within 1 year and pay the fee and continue on with prosecution. The Canadian Patent Office a couple of years ago has said that they will not permit advanced examination for those cases or for any other cases where an extension has been required. The policy reason being that this process is only available for applicants who want a quick expedited allowance of their case, and therefore delays such as abandonment and reinstatements or requests for extension don't fall within that ground. This may not sound like a big issue, but what I've found can be a bit of a pitfall is for applicants that use annuity services. for paying maintenance fees. If you recall, I had said earlier, maintenance fees are due annually in Canada. What we find fairly frequently, or I should say not infrequently, is that we will get instructions for payment of a maintenance fee after the deadline, in which case we will abandon, the case would have gone abandoned, and we will reinstate it and pay the maintenance fee, and that is fine. However, if that happens in a case that is under expedited prosecution, the Canadian Patent Office will put it back into regular examination and will not consider expedited prosecution any longer. So for the people who use annuity services, it's very important to make sure that they send instructions for maintenance fee payments to us well in advance so that those deadlines are not missed. Another option is the patent prosecution highway. I'm sure many people are familiar with it. It's multiple patent offices worldwide have issued programs like that. It's basically just an option for accelerating examination in Canada based on claims allowed or issued by another patent office. Currently, the Canadian Patent Office has about 10 PPH programs. The US, Japan, Korea, Germany, Spain, Israel, Denmark, Finland, the United Kingdom, and the Canadian Receiving Office of the PCT. The basic premise of the bilateral agreements are very similar. There are some differences in specific requirements. There are no government fees associated with the Patent Prosecution Highway Program in Canada right now. They're all considered pilot programs. As far as I recall, they all have an initial expiration date of 2 years from the date of inception, which can be extended. The United States did have that, and then it, I believe, has now been extended enough that the expiration date is considered indeterminate. I believe recently a number of the other PPH programs have also been extended. So it's something that certainly the Canadian Patent Office is finding very useful. As with the special order request, a PPH request must also be made with a request for publication and examination if that has not already been done. When the PPH programs first started, there was a requirement that you could only accelerate patent prosecution based on allowance from the Office of First Filing. That requirement is currently no longer in place, though again, I believe that is a pilot initiative, and it's not clear if that's going to continue. Certainly, patent prosecution highway programs can obtain allowance very quickly within 12 months of making the request, which is actually quite stunningly fast when you consider that it can take 3 years to get a first office action under regular examination. For the patent prosecution highway, there's a specific exceptions, so that if you do, for whatever reason, late payment of the maintenance fee, allow the patent to go abandoned and then reinstated, that does not make you ineligible for the patent prosecution highway. The big issue that I've encountered, and that I encounter more in the life sciences fields, is that the question of claim scope and divisional applications. Canada has a very generous and sort of broadly interpreted unity of invention provision. In addition, Canada prohibits double patenting, so you can't get two patents granted on what's considered the same invention. When you take those two doctrines together, it can make going through the patent prosecution highway not advisable. This, I find, happens particularly when we have, for example, a US patent granted, and the applicant comes to us and says that they want to go through the patent prosecution highway based on the claims of the granted claims in the US. As I'm sure all of you here know, US restriction practice is incomprehensible to me, but it's very, very different from the Canadian unity of invention law. So, for example, if you get a US claims on a product, but you have method claims in a separate application, in Canada they would be considered part of the same invention and therefore would have to be prosecuted in the same application. Therefore, unless you're willing to completely give up those method claims in the US, you really shouldn't be opting to use the patent prosecution highway in Canada, because that is all, you will only get claims that have been granted in the US. Any other claim would not be eligible for the patent prosecution highway, and you'd run the risk of double patenting if you tried to file a divisional application with those method claims, because they could have been prosecuted in the first parent application. So that is really a very big issue, and I've had a number of applicants reconsider their decision to enter the patent prosecution highway in Canada based on these considerations. The last initiative that we have for accelerated examination is what's called the Green Technology Initiative in Canada, which are for applications relating to technologies, the commercialization of which would help resolve or mitigate environmental impacts or to conserve the national environmental resources. As with the patent prosecution highway program, there's no government fee and there's very short time periods for responses to office actions. The problems with the Green Technology Initiative is the definition of what actually constitutes a green technology. So what falls within the definition that I just read out to you earlier is unclear. It's a new initiative. It's not, has not been tested. And so, we've had lots of discussions in our offices about, well, what would really be considered a green technology, and what are the penalties if you're incorrect, because the applicant must submit a declaration, essentially attesting that the technology relates to green technology. The Canadian Patent Office has pretty much categorically said that they will not verify whether the declaration is correct or not, but there's no indication of what the consequences of an incorrect declaration might be. Based on other case law in Canada, I would say that a good faith declaration would probably hold, but it's an area of uncertainty that, that needs to be considered. So I have a few green technology applications pending, and in all of those cases, we spent a fair bit of time convincing ourselves that it would be something that we would very confidently be able to say was in fact a green technology. As with the special order cases, applications that are abandoned and reinstated, or for which an extension of time has been granted, are not eligible, and if either the abandonment or the extension happens after acceptance into the green technology program, they would be taken out of that program and put into regular examination. So again, not usually a big issue, but it's the maintenance fee payment that sometimes slips through the cracks and needs to be taken into consideration. So in conclusion, there